So, what happens when a disease doesn't have a single cause but lots of different culprits? Who's supposed to pay? Today, we're going to try and unlock the legal puzzle of Barker versus Corus, a case that really changed the whole definition of responsibility. Just imagine this for a second. You've got a factory worker who was exposed to a toxic substance for 40 years, but at 3 different jobs. Then, decades later, they get diagnosed with a fatal disease. So, which exposure was the one that actually caused it? And if you can't prove which one it was, who pays? That's the impossible question at the heart of this case. Okay, so before we even get into the courtroom drama, we've got to start in the doctor's office, because this entire legal battle really hinges on the tricky nature of one specific and absolutely devastating disease. That disease is mesothelioma. It's a fatal cancer caused by asbestos. And to really get this case, you need to remember 2 key words: latency and indivisible. Latency just means it can take decades for the disease to even show up. But indivisible, well, that's the real kicker. It means science literally cannot tell you which specific asbestos fiber was the trigger. Any single one of them could have been the fatal one. This timeline right here shows you exactly why this is such a legal nightmare. You've got someone who works for employer A, then B, then C over a 45-year career. Each one of them exposes this person to asbestos. Then 20 years into retirement, bam, a diagnosis. All 3 employers clearly increase the risk, right? But how on earth can you prove which one of them delivered that single fatal fiber? You just can't. So this medical reality, it created what lawyers call an impossible proof. The traditional rules of justice, well, they just weren't built for a situation like this. For centuries, the law has relied on this thing called the but-for test. It means a victim has to prove that but for this one company's negligence, they wouldn't have gotten sick. It's a really high bar, and it demands this super clear direct link between one single action and one single outcome. And this slide just lays out the collision course perfectly. On the left, you've got the law demanding you find the single culprit, and on the right, you have medical science saying, sorry, that's impossible. So what's the result? Well, under the old rules, a victim could sue 3 companies that were clearly negligent and still walk away with absolutely nothing, all because of this impossible burden of proof. So you have this huge gap between science and the law, and it's creating this really obvious injustice. The system had to do something. It had to find a new answer. And the case that forced its hand was Barker versus Corus. So in 2006, the House of Lords, which was the UK's highest court back then, took on this very case. And let me tell you, their decision was going to fundamentally change how the law thought about responsibility and risk. So if finding that one single source of blame was impossible, the court came up with a pretty radical solution. What if you just stopped looking for one? What if instead you shared the blame? They called it proportionate liability, and it's a complete 180 in thinking. Instead of asking, hey, did you cause the disease? The law now asks a different question. What was your contribution to the risk of the disease? Each defendant is now only responsible for their piece of the pie. So you might be asking, okay, how in the world do you calculate each company's share of the risk? Well, the court landed on a pretty practical solution. You just use time. As you can see in this chart, liability was divided based on how long the negligent exposure lasted. So, if you spent 40% of your career at employer A, they were considered responsible for creating 40% of the risk. And this is the absolute key takeaway here. Under the old all-or-nothing rule, employer A could have been on the hook for 100% of the damages, or 0%. But with proportionate liability, nope, they're responsible for exactly their share, 40% of the compensation. No more, no less. And this new rule, it basically created a simple 3-step process, super straightforward. First, you figure out the total time the worker was negligently exposed. Second, you calculate each employer's percentage of that time. And third, you assign the financial damages based on those exact percentages. It's kind of like a mathematical solution to this really deep human problem. Okay, so this solution, it definitely provided a path forward. But it also raised its own set of really complex questions about what's truly fair for everyone involved. So let's break down the key takeaways from this whole thing. First, and this is the big one, liability is now all about creating risk, not proving you caused the actual disease. That's a huge shift. Second, because of that, it totally moves the law away from that all-or-nothing game. Blame can now be split up. But that leads us to the third point, and, this one's pretty tough. If one of those companies has gone bankrupt and can't pay, well, its share of the money is just gone. The other companies don't have to cover it. That loss falls right back on the victim. So ultimately, like the final point says, it created a more nuanced view of justice, for sure, but also a much more complicated one. And that really leaves us with a big, lingering question, doesn't it? The decision in Barker versus Corus, it for sure created a system that seems fair to defendants, right? Holding them accountable only for their piece of the puzzle. But in doing that, did it accidentally place a new and sometimes truly tragic burden back onto the victims? It's a puzzle of justice that, honestly, we're still trying to figure out today.